Yes, we are live now.
Okay, thanks Mohit, thanks Sanchita.
A very good afternoon to one and all. It is a matter of immense pleasure for all of us at CAREAP, that is the Center of Advocacy and Research for the Environmental Laws and Animal Protection, on behalf of National University of Study and Research in Law, Ranchi, to invite all of you for the second session of the E-Conclave on Environmental Law on the occasion of World Environment Day, that is today, that is 5th of June 2020. Now, this is the second session where ma'am is going to throw light on the topic, Inculcating Environmental Compliances in Businesses, Legal Prospects and Challenges. Let me give a brief introduction about Ms. Els Reynaer Kini. She is a partner at Kini & Company and heads the firm's environmental practice and is specialized in environmental law and nuclear law. She has law degrees from the Free University of Brussels, Belgium, and the University of Delhi, India. She completed an LL.M degree at the University of Georgia, that is U.S.A, which included a thesis on the regulation of transboundary movement of hazardous waste. Before moving to India, she worked as a lawyer on the environment and energy-related issues at Allen Overy, Brussels, and at Giordano Associates, Chicago, U.S.A. She serves as the General Secretary of the Nuclear Law Association of India, which she helped co-found, was the President of the International Nuclear Law Association, and was the Senior Vice Chair of the IBA's Environment, Health and Safety Law Committee 2017 to 2018. She has also received the 2019 Internationally Advisory Experts Award under the Environmental Law Award within India category. She is regularly recognized as a leading environmental lawyer in India by the WHO's WHO Legal Environment Edition, including in 2020. We welcome you, ma'am.
Thank you so much, Sanchita. Thanks, Mohit, also for setting this up. I think it's very brave from your side to try to break the boredom at home by organizing this. So congrats to both of you and the entire team. So I think, Sanchita, the way I understand is that we'll make this an interactive session. We'll do it a bit Q&A based, and then the students who are watching can also post their questions.
Mohit will be there to moderate, because I think it will be an interactive session with all the questions that will be coming up by the participants, and I think he has framed the questions also. Yes, Mohit, over to you.
Thanks, Sanchita.
A very good evening, a very warm good evening to one and all present in this session. On behalf of Center for Advocacy and Research in Environment and Animal Protection, I heartily welcome all students, academicians, environment law enthusiasts, and practicing advocates to be a part of this session, which is being hosted as a part of E-Conclave on environmental law on the occasion of this World Environment Day. Thank you very much for joining this with us. The CAREAP was founded in the year 2016, and since then we have always endeavored to initiate discourses on much neglected aspects of environmental law. Although we do understand that much of the development of environmental law has been due to the judicial pronouncements, yet we think that restricting environmental law to constitutional litigation, or for that matter PILs, will be a gross injustice to this interesting domain of law. Friends, today we are being joined by a very esteemed speaker and one of the leading environmental lawyers of India. I welcome you wholeheartedly, ma'am. Thank you very much for joining us.
Thanks, Mohit.
To provide a brief overview of what ma'am does, uh, ma'am clearly guides, ma'am
Yeah.
often
still hear
guides
me?
corporations, often guide corporations, leading corporations uh, to from a long-term risk management perspective by chalking out a compliance strategy for them, by obtaining and renewing environmental clearances and under the various applicable laws. Some of the aspects are water pollution, air pollution, forest related consent, registrations, and approvals. Uh, Thank you very much, ma'am, for joining us. And it will be a very intellectually enriching session for all of us at the CARE app and also at the National Law University, Ranchi. If you allow us, can we start the Q&A session?
Sure, Mohit. I look forward to it. Yes.
Okay. So, ma'am, the purpose of organizing this talk today is to debunk a major perception that business and sustainability are contradictory to each other. Both cannot go hand in hand. So it's a very wide perception. Uh, so what do you think that the question of business and environmental law, can they go hand in hand? Is it possible for us to do economic growth, to do engage in economic growth and sustain our environment for our upcoming generations at the same time?
Good question, Mohit, and I think it has kept the international community busy since 1972 when they really had the first international conference in Stockholm on the human environment, and followed up by the Rio conference in 1992. So luckily enough, we've made, I think, quite a lot of progress since then, if we reflect back on those 50 years. And I think even in India, many companies by now are at least familiar with environmental laws. And of course, some companies will be more progressive, more proactive in the various degrees with which they try to approach this sustainable paradigm. And you have different dynamics which influence that. You refer to the judiciary, but I think even from sometimes just a pure business perspective, I think companies in India very much realize that having a good environmental record or environmental management system in place is also appreciated from a supply chain perspective. When you do business globally, when you're looking at, even when foreign investors are looking at making investments in India, a possible merger, acquisition, companies, and I think many Indian companies are aware that score higher on that environmental compliance record will also be much more attractive. So there's also, I think, an incentive from companies themselves, just from a pure business perspective. Then I also think companies increasingly also understand that sometimes environmental compliance doesn't necessarily has to be at the highest cost. I think many companies sometimes understand maybe a little too late. If we, for instance, discuss and touch upon the VISAG, the explosion we recently had, right, with a polystyrene LG. So it's polystyrene is compound that is very much been in the market for a very long time. This is not the case, for instance, what I'm trying to convey is this is not the case where the company may not have been environmentally compliant, but clearly it showed human error at different levels. And it also shows that some of the systems, the safety measures may not have been followed as they opened up after lockdown. It also showed that actually very maybe basic or simple steps would have been able to prevent such an accident. So it also tends to show that environmental compliance or an environmental good record doesn't always has to come at a very high cost. So therefore, I think increasingly companies do realize it's good to have a robust environmental management system in place, particularly because once you have an accident, the costs always outweigh, the preventive measures. So therefore, I think companies also understand that it's in their own interest to have robust mechanisms in place.
Yeah, you the remark made by you is very true, ma'am. Actually, as you just said, that companies who have a clean track record of maintaining complying with environmental norms, they are valued by society. They are valued by shareholders. If that company is a listed one, that it basically adds to the goodwill of the company.
Yes. Yeah.
Moving on to the next question is, ma'am, since many of our audience today is from a non-environmental law background, we are being joined by students who have little knowledge of environmental law. We are also being joined by academicians who are specialists in some other domains of law. So I would request you to please provide a brief overview of major environmental legislations prevailing in India. And including the subordinate legislations. For example, we have regulations, rules, notifications.
Yeah.
Over to you.
Okay. I'll try to do that in a nutshell. But of course, I do think from a historical perspective, even here, India has seen quite a growth. And again, I referred to the Stockholm Declaration earlier, and it remains an important international pivotal point, because I do think your Water Act was adopted 2 years after, so in 1974, and the Water Act
74.
Yeah, 74, yeah, was important because, of course, it tried to regulate effluents and discharges, which could pollute water. In broad terms, there are, of course, more specific definitions. Importantly, it also created within that Water Act the governance structures of the enforcement agencies, that is the State Pollution Control Boards, and then the Central Pollution Control Board in Delhi, which then have outgrown the limits of just the Water Act, and now, of course, both the State Pollution Control Boards and the Central Pollution Control Board oversee a vast range of environmental laws. So this was, of course, predominantly the one act, and then early 80s, in 1981, you had the Air Act, which sought to regulate air pollution. That is still very much in place. And then, as you know, at last, you had the major Bhopal gas tragedy in 1984, and that was a wake-up call, I think, globally for many countries to review their own domestic environmental laws, but certainly also in India. And at that time, so after the Bhopal gas tragedy, I think for the first time there was also the creation of a Ministry of Environment. It was moved out of the Department of Agriculture and another Department of Environment. So just to have a dedicated ministry. And you also had the adoption of the Environment Protection Act in 1986, and then related rules. And the Environmental Protection Act, as on date, still is what they call an umbrella act, and it is under the EPA Act that, even as on date, most of, for instance, the waste management rules are being adopted. Importantly, you had another big impulse. I'm just trying to go a bit historically here. So in 1989, for instance, in India, they also adopted the hazardous waste management rules, and it was driven also by the adoption internationally of the Basel Convention on the transboundary movement of hazardous waste. And you've seen it also through the history that in India also has responded. It has shifted its response, so let's put it like that, because I think initially many countries just saw it as a business opportunity to receive the waste from other countries, where, of course, there are enough Supreme Court cases, but then, of course, you have active NGOs who then, of course, pointed out that there are quite a lot of drawbacks as well. So as a result, over the years, for instance, the hazardous waste management rules have been last amended in 2016 with strong regulations in place. I remember even when I came to India 20 years ago, that was only perhaps implemented half-heartedly, whereas now that's a very robust mechanism. Every state pollution control board very much monitors that. Companies have to be aware. You have to obtain an authorization from a state pollution control board whenever you generate hazardous waste, whether you transport it within India or you plan to export it. But of course, you've seen, and then subsequently, if you were to continue, you have a couple of other legislations that are really a bit driven by treaties. For instance, you have the ozone depleting substances rules that were adopted in 2000. That's also subsequent to an international treaty in that context. But increasingly now, if we look really at the last 10 years, you have very significant waste management legislations or rules that have been adopted. One of them, which is very relevant, is the e-waste. The e-waste rules, that means that any electrical or equipment that is put on the market has to be monitored by the producer who places it on the market. And these later, let me call them the 2016 waste management rules. So you have the plastic waste management rules, you have the construction waste management rules, and then of course the e-waste rules. And currently you have the draft batteries waste management rules 2020 being discussed. What all of them have in common is they've introduced new concept of the extended producer responsibility. So it's really, again, trying to, because I think some of your questions also relate to command and control or market-based incentives. And what you do with a system of EPR, or the extended producer responsibility, is that you indeed make the producers of goods, let's say, that can become waste, you make them responsible, and it is their duty to set up a mechanism. They can collaborate with other companies, they can collaborate with the local rag pickers. They just have to come up with a system. And these rules also specify that over the years, because they realize that from day one it's impossible for such a producer to perhaps take back all the waste, because it's quite complex to go and do door-to-door or consumer pickup. So these companies then receive targets over the year. So you may start at 10% of the calculated waste that must have been generated by your goods. You have to ensure that you recoup that and you bring it to the recycling plant or for disposal, and that increases over the years, and where you then target 70% at least in the coming years, that these companies have to ensure that they recuperate the waste. So you try to make companies responsible in that sense. And I think there've been a bit attempts even in 2011 to come up with such mechanism. They were not so successful, but I think now India is definitely somewhat on track. So you see an increased waste management regime, different streams. It can be plastic waste, batteries waste, e-waste, hazardous waste. That is important. That's an important evolution, where I think in the 90s you just had hazardous waste, that's it. You see that trend. Then, of course, another important piece of legislation which has come out in the form of a notification, and which is also there's an amendment in, for instance, the environmental impact assessment notification that is currently open for public comments. And so here the approach is, and it all relates back, of course, also a bit to what you were asking about sustainability. What the environmental impact assessment notification tries to set up as a mechanism is that companies who know that their activities, it could be a manufacturing unit, it could be a construction, it could be drilling for oil. So there's a list, there's actually an exhaustive list in the environmental impact assessment notification. And if you undertake any of those activities, you at least, depending on the scale of your project, you will have to undertake what they call an environmental impact assessment report in order to obtain an environmental clearance. And that's an important mechanism, because at that point, you'll of course have an expert appraisal committee, but ultimately you'll have the authority within the environmental departments of the state, or at central level, the ministry, who will review and impose conditions. What are the terms? So they don't want to stop the business, but if you undertake this manufacturing plant of, let's say, toys or elevators, you can be either you're allowed to be in a particular location, or sometimes the review says you're not allowed to be in that particular area. You may have to find a different plot. But even if there's a allowing of the specified activity, conditions will be imposed in terms of your pollution level and how to control the impact on the environment. So they'll have to study the area around, the biodiversity, the groundwater flow. There are many parameters. It's a very technical report. It's reviewed also by technical people who will then impose conditions and parameters that companies will have to keep complying with. I think in India, as I mentioned, yeah, please.
Yeah, ma'am, I think you have provided a very brief timeline of the entire environment law jurisprudence which has developed in India since 1974, the Stockholm Conference. And moving on to the next question is like, what are the key regulatory bodies enforcing compliance, enforcing environmental norms in India? Please provide a brief overview of this.
Yeah. So as I said, I think the enforcement agency par excellence is each state has a state pollution control board, and then of course there's a central pollution control board, and most companies will have interacted with any of those enforcement agencies simply because they also supervise, as I mentioned, not just the Water Act, but any company willing to set up a plant will have to first obtain what they call a consent to establish. It will have to approach the State Pollution Control Board and request, apart from, not all companies have to obtain an environmental impact assessment report, but most companies have to obtain anyway this consent to establish, in which case the State Pollution Control Board will review what type of activity do you propose to undertake. And even here, so you first have to obtain, as a company, consent to establish. Once you're ready, your plant is constructed, there will be an inspection. Members of the State Pollution Control Board will come to the site and will then inspect, impose further conditions, and then you obtain a consent to operate. In many other jurisdictions that may be referred to simply as an environmental permit, here it's a consent to operate or a CTO, and that you have to renew on a regular basis. And companies, and you'll have these SPCB officers do have the right of inspection. So companies know that they can have surprise visits, and that happens regularly also. So that's one way to monitor the compliance, where they will come and compare the conditions that you have in your environmental permit. That's again very technical. It can say your BOD and COD levels of your effluent go into the common effluent treatment plant has to be this level. We see you discharge that level. Kindly explain what is happening, etc. And then of course everything. So we that's where I think us as lawyers, our team also often comes in the picture, because then you have to understand the gravity of the situation, how this can be turned around. There's of course a right to be heard by the company as well. There may be a valid technical explanation or not, or a company did face, there may have been an accident on site and therefore parameters went off, but they need particular time to get it back on track, etc. So this is then a way, so these are your most known enforcement agencies, simply because companies also interact with them on a very regular level. Then, of course, we have specialized enforcement agencies as well. I've not referred so far, for instance, to the fact that even the Convention on, for instance, biodiversity has led in India to the adoption of the Biodiversity Act. Well, you have special bodies within that regime. Yeah, then you, of course, I refer to environmental impact assessment and then the authorities within that. Similarly, you must be familiar also, you have a CRZ notification with regard to that is the coastal zone regulation that is specific. So you have separate bodies for that. Then even you have a Forest Act, and you'll have a separate bodies in that, for which at times, depending on the type of activities you propose to undertake, you will have to obtain an authorization as well. But I would say, in short, the most common and widely known enforcement bodies would be these state pollution control boards, and of course the Central Pollution Control Board, which the CPCB will come often in the picture, not just because it develops a lot of technical guidelines, but for companies who are active in more than one state. I think that's, yeah, in a nutshell, in terms of the enforcement agencies.
I think, ma'am, you have provided a very brief overview of all the regulatory bodies involved, all the legislations which are into play in India, and what are the key consents, registrations, and approvals which are required for establishing a business in India. Moving on to the next question. In the year 2010, we saw that entity was established to revolutionize the dispensation of environmental justice, and the principal motive of the government was to make the companies more sustainable, to as a country to be better placed in terms of climate negotiations, so that they can show at home that we do have such innovative environmental justice dispensation mechanisms. So how do you evaluate the role of National Green Tribunal in enforcing compliances and enforcement of environmental law? It has been a decade of its establishment. So how do you evaluate it?
Yes, and indeed, and you have a very interesting report also made by the CSE on looking back at 10 years NGT, and looking at all the cases dispensed by them. Overall, I must say, I think I have quite a positive feedback. Of course, that CSC report also aired some valid criticisms in terms of that it could, how shall I say? I'll first say why I do appreciate. I do think the NGTs, in the same vein as really the High Courts and the Supreme Court in India, remain very activist bodies. It has the advantage of not having faced too much and still handling, but not these cases without too much delay. And these are very knowledgeable members at the NGT. So I think by and large, the criticism that has come up maybe at times is that in the context of enforcement, and you can, of course, see, I think some of your questions subsequently also ask about enforcement. And the fact is, for instance, in India, you have very progressive case law. But then sometimes people do ask, well, what has changed on the ground? And this is, of course, also sometimes where you see the frustration of the judiciary, including people in the NGT. And I think it pierces through in their judgments as well, where the criticism maybe is that at times, you know how courts in India do impose exemplary damages or punitive damages, surely to an extent, even in the civil, so in the non-criminal context, simply to punish the behavior of the company and to serve as a signal to all other companies that the seriousness or the nonchalance and the negligence with which some of these activities and environmental damage has happened will be punished. And here, if you read through many of the cases of the NGT, what they end up doing is maybe imposing by way of exemplary damages, for instance, 10% of a project cost, or 10% of the sales of a company. And here it is felt that, yes, so it is important, because in India, typically the weakness was always that the penalty amounts are so low, right? So here you see a bit a counterbalancing where very often both the Supreme Court, the NGT in that way follows the Supreme Court case law also, tends as a rule of thumb perhaps to impose 5% of these of the turnover or the sale of a company, and that of course is not always. Sometimes it can be an exaggeration, sometimes it is insufficient. So here the criticism is a bit that it should be a bit more transparent. It could also be more fine-tuned in how you arrive at these environmental compensation amounts.
Yes. So, ma'am, one of the key argument which is advanced by the critics of National Green Tribunal is that it is a kind of toothless tiger. It does not have to pay lip service to the government. It has to, it kind of informally has to align with what the government says, because ultimately it has also to ensure the development the development perspective of the executive branch. So how do you respond to that?
Well, I think in that sense, the NGT, just like to that extent, the High Courts and the Supreme Court follow a little bit the same pattern. I feel they're very proactive activists almost in many matters, except I always feel that there is this one carve out when it comes to large public infrastructure projects. That's where I think the larger public interest in the eyes of the judiciary, whether it's in terms of the construction of a highway, the construction of a dam, these type of large infrastructure projects, that's where indeed I feel you may not see the same type of activism, as some call it, in the judiciary. But I would and so indeed, even in that CSC report, that's a bit the criticism that they very rarely go against the positions of the government. I would be a bit more nuanced, that I feel it's really in terms of these large public infrastructure projects, and to that extent confirms a bit the pattern even in the High Court and the Supreme Court. So I don't think that's unique to the NGT, and this criticism should not overshadow also. I do think what otherwise the NGT does rather well, in my opinion. The frustration, of course, about things not changing on the ground, again, is the same for Supreme Court judgments as well. I've gone to sites where mining was banned and where mining happily still took place despite a Supreme Court order not to do so. So that's, I think, a general frustration that can be seen in terms of the enforcement of all your judgments.
Okay. Ma'am, as we know, environment law is a very new domain of law. It is being developed on the existing doctrines. For example, one we have is the absolute liability doctrine, how it was adapted in the Indian courts. And so environment law, what I'm trying to say is environment law is a very new domain of law, and there are various areas and aspects which still need imminent and urgent attention of the government. So from your perspective, I want to know that what are the areas and aspects of environment wherein there is an imminent and urgent need of legislation?
Yeah, I think the one area where I've always been surprised when you look at it from a comparative perspective, India, as on date, still doesn't have legislation addressing soil pollution. But as in many other jurisdictions, that's a very important piece of legislation, and it influences, and it has vast repercussions, because it abroad, if you were to look in many European Union countries, the US for sure, it also means that at the time of our merger acquisition, a takeover, assessing the level of soil pollution is important, particularly because what these other jurisdictions try to impose is also a liability for historical pollution. So it is no excuse when you say, well, maybe there was a chemical plant in the 60s who just dumped all their chemicals in the soil, but we're making a completely different type of goods and we don't use these chemicals. Abroad, the new owner may still be held liable to be in charge for that historical pollution. And that, to my great surprise, although you understand a bit, of course, that the Indian context, these remediation of these soil remediations are also very expensive. And I think even abroad, they've moved away from too draconian an imposition. So there is a bit a draft study on trying to adopt, at least it has to be addressed any which way, this soil pollution, even though I do think the draft that is on the anvil is quite balanced in that it tries to perhaps ensure that what the law will say in the future is not the soil has to be absolutely clean again, because that would be financially almost unviable for most countries, but where you do take into account, okay, so this is the soil pollution at least will have to be treated up to a particular level in an industrial estate area. If you're closer to a residential area, it has to be remediated to even higher level. And that is definitely a lacuna that has always been there. But I'm not sure with which haste such new legislation on soil pollution will be adopted, because the draft has also been floating for a while. But that's otherwise an area that definitely would need to be addressed. Then I do think where you see interesting momentum, and for all of you, it'll be interesting to study also, is that you have a new chemical safety and management draft rules also being adopted now. They're also open for public comments, and that would be a completely new regime, a bit similar to what they have in the European Union, which is called REACH, and would really require both importers but also domestic companies who place certain goods, or who import, when you import particular chemicals, that more information is provided on these chemicals. Studies will have to be submitted by these companies on impact on environment, impact on health. So studies will have to be undertaken by companies before they get the green light to place hazardous chemicals, or will be defined as hazardous substances in that draft rules, and that will be a new paradigm shift whenever that is adopted. And I do think that will be an important contribution also. So in that sense, the gap will be plugged in that area.
Okay. So the other day I was reading your one practical guide written by you on LexisNexis UK, and in that practical guide you have mentioned that white asbestos has not been banned yet. It needs urgent attention of the regulatory bodies and urgent attention from the executive wing of the government. Thank you very much, ma'am. And moving on to the next question. So it is one of the main questions of this session. What are the major legal reasons? What are the major legal hurdles which prompt the companies to non-comply with environmental norms? What are the reasons behind non-compliance of environmental regulations, norms, for that matter?
Yeah, I think in this session probably we can call a spade a spade. I do think I've referred, of course, to the enforcement agencies, and we interact with them, and I respect many officers that we work with. But I think overall the governance of these SPCBs in particular has to be upgraded. So in short, I do think the non-compliance and more so in some states than in others, a lot has to do with the fact that these SPCBs don't always function at optimal level. And I do think, but it doesn't just has to be a negative criticism. I think even if you look comparatively, there are a lot can be learned from how it can be approached, whether you look at enforcement agencies in many other jurisdictions, whether you look at the US EPA, you have to ensure that you attract bright, driven officers, have competitive exams, have competitive packages, make it, abroad, even in our enforcement agencies, they succeed in attracting very driven, motivated, be it chemical engineers, environmental lawyers. It's just, it's a very appealing prospect to work in some of these enforcement agencies. And that here, it just requires a complete overhaul. I do think you have to manage better, stronger. You have to have larger teams. They just have to be expanded. Competitive exams, both for lawyers as well as all the engineers who work there, have to be introduced. So I do think the weakness of the executive, which in India also explains the proactiveness of the judiciary, remains a major fault line in the enforcement landscape. I think that's a major weakness.
Okay. Moving on to the next question, ma'am. Recently, we saw in Surat that emission trading system was commissioned. A pilot emissions trading system was, started to look at the prospects, how it can be implemented in the entire state of Gujarat, or for that matter, in the other states, to regulate emissions, to control emission standards. And so do you think that command and control measures are outdated and need to be replaced with new age policy instruments like environmental taxation, emission trading systems, for that matter? Over to you, ma'am.
Yeah, Mohit. No, it's a valid question, and I think many jurisdictions have the same type of discussions. To an extent, I think all these tools are not mutually exclusive, and you may, depending on the type of pollution or environmental aspect that you're trying to address, you may opt for one as opposed to the other. So I would not just presented that market-based instruments just have to replace all the command and control approaches. There's value in these market-based instruments, and certainly, particularly when it comes to air pollution, we've seen in other jurisdictions that have been successfully implemented as well. And if it gets companies to comply with these laws, why not? It's certainly worth the experiment. Let's put it like that. Command and control, to an extent, still reflects the idea of the polluter pays principle. So I would not just simply do away with it, but and it links a bit back to the weakness that I see with regard to the enforcement agencies. I think one of the major drawbacks, I do think, in India in the enforcement regime is that there are no constructive communication channels with these enforcement agencies. So as a result, indeed, it becomes a very black and white type of approach, because, of course, even officers, you do have a lot of motivated officers in these SPCBs as well. They may then get very frustrated, or the judiciary has just asked them what is happening in terms of the implementation of the plastic waste management rules. I've not seen anything. And so they'll send notices to all the companies, and then it becomes a bit this rough approach, and everyone gets punished, so to speak, gets notices in the process. And what they lack is a communication system, because you should actually try to find, even in whatever tools you use, try to give some incentives to companies to come forward. It is a fact of life. You may have just done a takeover of a company, discovered things you had no idea were in place on site, and you have to deal with the pollutions left behind by the company that you just took over, or an accident happened. And the problem is, in India, companies do not dare to approach the pollution control boards, because they fear this command and control has become a little bit too draconian. So they fear any disclosure will lead to a closure notice. And then, of course, whereas you should actually create incentives for companies to come forward and receive a benefit when they come forward, because ultimately the focus is not so much on the punishment, the focus is on remediating the environmental pollution that is present. And so to arrive at be more solution oriented, understand a business perspective as well. It is not always pure negligence when accidents happen. Sometimes latest technologies may not have been there, or oversight, or as I said, merger of companies, different cultures. And in the current command and control, there's simply no room for a company to come forward and explain that to a pollution control board. So the companies would rather not disclose anything, continue maybe with the ongoing pollution, rather than having an incentive to say, I'll come forward, my penalty will be less, and at least I have found a solution. The fear is simply, I come forward, I will be asked to close my factory. And that is not an ideal type of command and control. Am I still audible? Mohit, you still there? Okay. Should I message Mohit? I'm just trying to see where my phone is. I'll try to connect maybe. I'm still showing as going on live, but I missed Mohit to moderate the further questions. So perhaps I'll just message him. Or call him. So I'm not sure whether other participants can still. Okay. Shall I just read some questions? The present practice of monitoring compliance to parties and the regulator. Yeah, it's a good question, Kumar, in terms of third-party monitoring. I think so far, of course, in the context of in India, we just see the experience a bit where courts, for instance, in the event when parties of pollution control board and a company may use different evidence, and of course, as a judge, one can't really decide one in favor over the other because it's always so technical in nature. So what courts do tend to do is appoint, then, for instance, people from NIRI, National Environmental Research Institute. These are it's a government body, but I do think NIRI inspires confidence because I think it's one of the few bodies where parties generally, or put differently, NIRI inspires confidence in terms of its findings. And I think it goes to the credit of the ethics of the officers in NIRI. They tend not to interact with either party and therefore have a very good reputation of being very ethical, and their final findings are therefore often seen as an honest final word on very technical matters. So I do think, going by NIRI, the idea of third-party monitoring, even independently of having a court case, would be a good idea. So I think it's a good suggestion, Kumar, or Saurav rather. Yeah. Are there any other questions that I can perhaps address while we wait for Mohit to... Okay. Hi, ma'am, could you comment on the relaxations of the CRZ notifications? actually, I don't have the latest draft in front of me, and I do think these remain a bit more controversial, no doubt, these relaxations. And that's, of course, certainly true. Like I also, in a city such as Mumbai, where you have such a density where, let's say, nature, business, and then, of course, these distances from the shoreline are also enmeshed with one another. So typically these CRZ relaxations are very much criticized by NGOs, and you at times do understand their position, particularly because you have these CRZ distances being made for entire India, and of course it applies then very differently depending on which state, which local situation you may have. But at the same time, it's important that you keep these notifications should not remain too static either, simply because the landscape changes, the business landscape changes so much, the density of some areas, the pure population and business density evolves. So it's important, just like with, let's say, the management, the normal zoning laws, it's important that you do update these on a very regular basis so they reflect as close as possible the ground realities, while at the same time trying to probably anticipate a little bit more rather than being too much post factum. I think sometimes some of these amendments have been imposed and then seem very difficult to implement on the situation as it has evolved on the ground. So I would suggest a more regular updating of these CRZ notifications, as well as zoning laws in general, to be more in tune and to regulate more closely what is happening in specific areas. So that's a good question. I think Mohit is also trying to. Yeah, Mohit.
I'm back.
No, that's okay. So I had two questions.
Apologies, there was some technical issues.
No problem.
It logged me out. So we have started receiving questions from attendees. And one very interesting question which we have received is that, remember last year Uttarakhand High Court pronounced a judgment stating that the river Ganga is an ecological entity, and several high courts followed a similar. Several high courts followed this step, and they started declaring ecological entities as legal persons. They meaning that they have their own set of rights, they can enforce it, and they have the legal personhood, the local standi which is required to stand in a court of law. So how do you see this development? Did it contribute to the environmental jurisprudence and led to a very positive development in environmental law, or is it just another judgment, we may say?
No, of course these are important judgments and evolution, just the way you see different evolutions when it comes to, for instance, climate change related cases. Perhaps it may be too early to really predict how much that has impacted here the legal landscape, but it's certainly in tune with what is happening in other jurisdictions, a bit internationally. I've just finished writing a draft paper also on for instance, also recent judgment by the International Court of Justice in the Costa Rica case, where it was important because the ICJ held that, yes, we will claiming compensation even between states for damage to the environment per se, that is even to all the components in the environment that have no inherent economic value, damages will be awarded, compensation shall be calculated even for those elements of nature. So you move a bit away from a pure anthropocentric view that only natural components, such as you've destroyed trees and timber, is sold at this rate, so therefore these are the damages we give you. But it's more in tune with, even if the beauty of a particular natural landscape that has been there for centuries is affected, even that should be compensated. And I think it goes a bit hand in hand with some of these recent developments, even in India, where you start then giving rights also to environment per se. I've not seen it taken off, but I can imagine how all these elements combined, and particularly I refer to climate change cases where some of the aspects may be more diffuse. It may be more difficult to really pinpoint at one defaulting company or one claimant. And then all these elements, of course, can tie up. And I do think increasingly we will see cases evolving in that direction. Although I think as of now it's been a bit modest, but I think it's a logical trend, let's say, that you see in India, and is in tune also with what is happening in other jurisdictions. Are you gone again, Mohit?
Hello. Okay.
You're back.
We will take 2-3 more questions, and we will then wrap this session up. Ma'am, there is an increasing tendency to consider society as an important stakeholder in businesses, and we have seen this by the enactment when the Companies Act 2013 was enacted, and subsequently the corporate social responsibility was mandated by section 135 of the Companies Act. And we also find a very similar species of corporate social responsibility in EIA notification, that is corporate environment responsibility. So how do you see these changes in the legal environmental legal regime? Has it made businesses more environmentally responsible, more responsible to society, that being concerned about the externalities, as we term them in economics? What is your perspective on it?
I do think, I mean, to be fair, I think that the CSR regime as adopted in the Companies Act 2013 certainly led to more of a upheaval and an awareness, and very much triggered all companies, of course, that fit the criteria under that section 135. So I think to that extent, and as you may also know, like they recently also tried to amend that section to try to impose penalties for non-compliance, but that has not been adopted, or at least the date of entering into force of that particular part has not yet been notified. But overall, so I think, yes, the CSR regime certainly has forced companies at least to discuss it in their board meetings. It has to be part of your annual report. So to that extent, and I do think it's a mixed landscape, of course. Some companies have taken the opportunity to really generally implement it and think of a local project by which they could really benefit the stakeholders in their immediate vicinity. You have many good examples. I'm not sure with the CER. I feel I have a bit more a mixed opinion. I don't think I see it more almost. CER is almost more transactional, but you pay a particular amount as part of your environmental impact assessment analysis, and then it doesn't seem to have the same long-term approach. I feel in that sense the CSR may have been a bit more successful and widely implemented, understood than the CR, which is more narrow in scope, was also initially mainly imposed there was before an amendment of the CSR to ensure that even companies who didn't have yet a particular net profit would nevertheless pay a particular sum. But I think the CSR has much more far-reaching effect, I feel, so far than the CER, which in my view I would have give it a mixed.
So can we term CER as a tax, as a kind of species of tax wherein you have to deposit some funds with the government, say 10% of the project component you have to deposit in the government funds. So how is it helping the businesses to make them environmentally responsible? Is it helping, ma'am? What is your perspective on it?
That's true. No, I think, I mean, if at all I could really ideally redraft, I would make the CR much more part of your CSR. This is also, it's also much less well elaborated. The CSR notification, the guidelines are much more specific. Many stakeholders are on board in terms of the implementation of a CSR project. And with CR, I feel it has been a little bit a smaller parallel system. And I think it would do well maybe if it were just to be absorbed much more directly in the CSR regime. So I'm a bit more critical on the value of CR, but who knows? It can take off separately in the future in a more significant manner, maybe.
We have received one question from Navantak. He says, despite a 38-fold increase in the number of environmental laws introduced globally since 1972, right after the Stockholm Conference, including the adoption of a constitutional right to a healthy environment in 88 countries, we have been consistently pushed more towards environmental non-compliance. So what is your perspective on this? What is the reason for this?
Yeah. Navantak, so relevant criticism. Of course, I'm not sure about the numbers you give, but we can have a certain frustration in India with regard to the non-compliance records. I've touched upon it already. I do think it is largely explained by the enforcement agencies not being robust enough. I also think they're way understaffed. So I think a major overhaul from a governance perspective in these SPCBs just has to happen. That is as on date still a weakness. So I think officers do their best. They're understaffed a little bit. And so yeah, so the non-ideal functioning of these bodies also make it such and of course I've not tried to be too negative on the SPCBs, but the fact is they, even when it comes to the ethics in these bodies, it just has to improve. A different mindset has to step in. So I'm absolutely in favor of a complete overhaul. Something has to be done. There are certainly very good officers, excellent chairmen of these SPCBs, but they're way understaffed, and the type of officers, the legal departments are too thin. It just has to be expanded and given more weight. So I think if you have, India certainly is the prime example of having such proactive judiciary, very proactive announcements when it comes to the precautionary principle, when it comes to exemplary damages. Like the courts go well ahead of many other, judicial pronouncements in other jurisdictions, and yet, as long as your executive and these enforcement agencies within don't level up, you will not necessarily see that translate in the necessary results.
Okay, ma'am.
Yeah.
Yes. We recently, very recently, a draft EIA notification was issued by Ministry of Environment, Forests and Climate Change, wherein the public consultation period has been reduced from the earlier stipulated time period to 30 days. So how do you see this change? Is it going to help businesses being more compliant or is it going to have a counterproductive effect on our collective sustainability efforts? Over to you, ma'am.
Yeah, I do think it is one of the weaknesses. There's some good elements that have come out of the environmental impact assessment notification, such as identifying projects, very small projects that don't need to go through the entire procedure. But it has been disappointing when we look at the public participation model. Not much has changed compared to earlier, apart from the reduction in time. And that is a missed opportunity, because I think the public hearings just are not functioning well in India. I don't know, you find enough, you should Google on YouTube, or on YouTube you'll find these are of course video recorded, and it's a bit it's a failure to think that a public hearing is a one-time tick the box interaction with the public, and then possibly an addendum to the environmental impact assessment report to say what you propose to do. Whereas there's enough experience even abroad with what truly functions well is to have a series of interactions with the local stakeholders, genuine engagement, genuinely understanding what are the issues. Sometimes there can be miscommunication, sometimes there can be different types of expectations. So it's very important. It cannot just be a one-day hearing with hundreds of people shouting, not well recorded. It should be, there has to be a constructive model set in place where you look at long-term ongoing interactions, and that it goes to the benefit, would go to the benefit of companies as well, to ensure that yes, you do have this social contract and approval to set up your company or activities. And I think even abroad, these type of ongoing interactions with local stakeholders always pay off. So I feel that is an absolute missed opportunity in this draft, not to have thought of a more robust public hearing or interaction model.
Ma'am, this question, okay, moving on to the next question. This one is from a law student's perspective. How to be a successful environmental lawyer? What are the qualities and skills a law student should look forward to inculcate in order to become a successful environmental lawyer during our stint at law schools? Over to you.
Yeah, of course, like I think like in any field, of course, you have to be a little bit, you of course have to be very passionate about the area. I also think it's good if you like science to a certain extent, because of course many of my day-to-day interactions actually maybe with engineers and not necessarily lawyers, because you have to understand the processes. You have to, even a lot of the annexes of your environmental laws are very technical in nature, so you should not be intimidated by that. You should rather be very intrigued by that, and it's always, it's an ever learning process. So I think if you're someone who both likes science and law, then it's a ideal field. And then, of course, as I mentioned, my practice area happens to be more on the corporate side. But then, of course, you have environmental lawyers who focus on litigation, and it's also an equally rewarding and important field. So yeah, I think in short, you have to be passionate, interested in the area, because it's a very dynamic field, and then also like science to a certain extent. Mohit, are you definitely logged out?
One moment. Ma'am, one
Okay.
last question which I wanted to ask. Please elaborate the nature of the work in an environmental law practice in a law firm. Like, what are the key stakeholders which an environmental lawyer is supposed to interact on his day-to-day in his day-to-day operations? What are the key commercial agreements signed in this domain, so that the students could have a clear understanding of the career as a environment law as a career perspective?
Yes, of course, it can be quite varied. As a corporate environmental lawyer, you can come in the picture at different stages, of course. One, which is a very interesting field as well, when you are young, there's all these environmental due diligences when you're part of just a corporate due diligence team. And then, of course, you look mainly at the environmental compliance part. So you'll have to go to the site, understand the business, look at which type of permits they have, analyze which type of permits they should be having. So that's one type of assignments that you do handle throughout your career as an environmental lawyer. And then of course, linked to that are then some of your agreements, as soon as, particularly, so we've touched upon various environmental laws, and let's just look at an example of a company with then imports particular items, and then we'll also need to rely on other parties to come and pick up the waste, send it for recycling, and so you have various parties with which you have to have a contract in place as well, that deal with your waste, or if it so that's the contractual part, where you'll have to make sure that you refer that there's clarity on each person's responsibility, liability, but then of course there are many other agreements in terms of your environmental, like indemnities also, of course, after your takeover of a particular company. We referred earlier in the talk also to some of the historical pollution. What happens, of course, if you discover these type of hidden or perhaps unknown pollutions that are left there by the company or its predecessor company. So that are type of agreements and clauses that you'll also have to draft. And then comes, of course, so this is talking from due diligence to the contractual part. And then, of course, comes the regulatory part, where you actively interact and handhold companies. We advise, for instance, in our team, in the law firm, we advise a lot of foreign clients who enter India, want to understand which all environmental laws do I have to abide by, how is it different from US law, EU laws. It also allows you to do this comparative analysis for them, guide them through it, assist them also, depending on their requirements, with obtaining these environmental permits. So we do interact also with regulatory bodies. And then of course, where if things fail, so to speak, then maybe you, of course, may also be involved in litigation. Although, as I said, when it comes to that part, I typically interact with my colleagues from the litigation department. So there's quite a variety also in terms of the work that we do as environmental lawyers.
Okay. I think we had a very interactive session, ma'am, and you highlighted very comprehensively right from the Stockholm conference, and thereafter we had Water Act, and the entire timeline of how the environmental law jurisprudence has been developed in India, along with the important judgments that came along with these, concerning the interpretation of these statutes. I think we had a very interactive session, ma'am, and I would like to pass this session on to Sanchita, ma'am.
Thanks, Mohit.
Indeed, a very engaging and knowledge-enriching session, ma'am. So on behalf of the Center for Advocacy and Research in Environmental Laws and Animal Protection, the Center, and the entire fraternity of NUSRL Ranchi, I extend my most sincere thanks to you for sharing with us the practical experiences in the realm of environmental law. Thank you so much, ma'am. I am also thankful to our very own Vice Chancellor, sir, the Professor Dr. Keshav Rao for making this event happen. Last but not the least, I am very much thankful to the students, the hardworking students and the members of CARE, without whom this event would not have been possible at all. I sincerely feel and hope that after this enlightening speech or the lecture or the interactive session, whatever you call, the participants will definitely have a sporting attitude to save the environment. Thank you for being with us.
Thanks, Sanchita. Thanks, Mohit. Thanks for the questions.
Thank you very much, ma'am. Thank you very much for joining us. And
Pleasure, pleasure.
Our honorable Vice Chancellor, sir, has also sent his kind regards. He was scheduled to join this web session, but at the last moment, he got a call from Honorable Chief Justice of Jharkhand High Court to have an important meeting, and that's how he was not able to join this session.
Yes,
But
yes, understandable.
anyways, he
Understandable.
has sent his kind regards uh, to this successful event. Thank you very much, ma'am. It was indeed a very enlightening session. And on behalf of the Department of Research in Law, the student fraternity, and the other stakeholders, I wholeheartedly thank you for joining us. And we wish to keep this collaboration with you and your organization for a sustained period of time. Thank you very much, ma'am. Thank you very much for joining.
Thanks to both of you. All the best.
Thank you.
Okay, thank you.
Bye.
Goodbye, ma'am.
Bye, bye, bye.